Okay, thank you, Nora, and thanks to everybody on the team here at the Public Law Library, and welcome everyone. Welcome to today's session on going solo, opening a solo law practice. We are here today at the Sacramento County Public Law Library in downtown Sacramento. We're just diagonally across the street from the Sacramento County Courthouse. And to those of you here, also welcome to those of you who are joining us by video at your home and your office, or you could be doing what I do, which is go to a coffee shop and get an espresso and put on my headphones, and you're joining us while you drink coffee and take notes. So wherever you are today, welcome and join us, and let's get underway. My subtitle is Don't Think Like a Lawyer, because my larger goal today is more than any particular fact or any particular idea, is I want to challenge your thinking and I want to jolt your thinking. And we all go to law school. We're all told that we're going to be taught how to think like a lawyer, but the world is changing and the world is different. So in our discussion today, I'm going to hope to get you to really challenge your thinking. And I also hope that today's session is going to be participatory and interactive and collaborative. I don't want to just talk for 90 minutes. I'd like to challenge discussion. I'd like to get your ideas. I'd like that we talk amongst ourselves. I do ask if you refer to any particular law firm or employer, keep the reference generic. Don't name particular entities. But I'd like to discuss our experiences. It may get contentious. We may get into a heated discussion here. I should put you on notice that in the event that there's an outbreak of fisticuffs, I will instruct the cameraman to turn the camera off. So I just want to put that on notice. And so let's talk about our presentation today, being a solo practice. Let me tell you first a little bit myself. Being a lawyer is my third career. I went to law school late in life. After undergraduate school, I was a newspaper reporter. I worked for the Wall Street Journal. From journalism, I decided I wanted to make more money, so I went into corporate public relations. I worked for 2 companies as a manager of press relations. And then after that, I decided I want to work for myself. I wanted both the growth opportunities as well as the kind of lifestyle that comes with being self-employed. And I had a public relations consulting business. It was a solo business. Helped companies do writing projects, annual reports, deal with the media. And I did that for 13 and a half years. Then decided I wanted more growth, went to law school, and now have my solo law practice. But I did gain a lot of insights from having a professional service practice. It was public relations. But nonetheless, I had to market, I had to find clients, I had to manage clients, I had to manage my own personal budget. So there's quite a few analogies. And I'm actually grateful that I had careers before becoming a lawyer. I know a lot of our colleagues go to undergraduate, they go to law school, and they really spend their whole working life as an attorney. And I'm grateful that I was able to bring some other career learning experiences into the practice of law. And I think you're going to hear today that it influences my thinking. And as you share your experiences with the rest of us, I enjoy having you reflect on other workplace experiences that you've had, either collateral to the practice of law or prior to the practice of law. Now, in law school, they often say we're going to teach you to think like a lawyer. And my premise today is that no longer works in this changing environment that we're in. Why doesn't it work? Well, take a moment to look through here. These are some of the attributes that I think go along with this mantra of thinking like a lawyer. So just take a moment here and read this to yourself. Anybody have any comment on any of these? Agree, disagree? The point I'm trying to make here is that the practice of law is not entrepreneurial. It is not entrepreneurial. It tends to rely on precedent. It tends to rely on this is how we did it yesterday and last month and the year before that. When I as a contract lawyer, would work for law firms, and it always used to drive me crazy when people would say, well, we don't want to reinvent the wheel. We don't want to reinvent the wheel. Just take this template, take this document and reuse it. And I'd say, yeah, but I mean, 80% of this is not relevant to the case at hand. That's okay. Go ahead and use it. This is what we use. Let's take, for example, the last bullet point, poor people management skills. Now, managing people is an acquired skill. Very few of us are born with a natural ability to manage people. Lawyers generally don't learn how to manage people. Your traditional law firm is a hierarchy. You have your senior partners on the top, and they're senior partners because 40 years ago they knew the mayor of Sacramento, and ever since then they've just been senior partners. And then they beat up on the junior partners, and the junior partners beat up on the associates, and the associates beat up on the support staff, and the support staff beat up on the temps. And it just goes on and on and on like that. And our economy today is much more of a network society where you're dealing with people on a contingency basis or on a project basis. And hierarchy doesn't work. You can't tell people to do something because, well, I outrank you and there are going to be serious consequences for you if you don't do exactly what I'm telling you. To be successful today, you have to deal with people either as peers or as co-workers or as fellow members of a network working towards the same goal. And that requires people skills. And if you think like a lawyer, you're unlikely to have people skills. The next one up is weak quantitative skills. I remember coming into a classroom and there was an equation on the board and people freaked out because they were in a law school class and like there was a mathematical equation on the board. Law school, you can get through most of law school with hardly doing any numbers or any quantitative analysis. We're in a different era today where aggregate data is the key to wealth and is the key to competitive success. There are some terrific programs now in data analysis. The world has changed. Words alone are not enough for success. You have to be a balanced person both with your words, but also comfortable with data and with quantitative analysis. Suspicious of innovation. The law is a very traditional profession. In fact, it glories in being traditional and hearkening back to the age of King George in England 300 years ago, or what happened here. I mean, our profession is based on precedent and is based on history, which is a good thing. It's part of the common law system, but it also inhibits innovation and makes people resistant. I think if you walk around a law office today, it could be the set of Mad Men. You know the TV show Mad Men? I mean, the culture, you have giant cubicles with secretaries who generally are female. Then you have fancy offices, which are the partners who generally are male. And then you have the churn of associates who come in for 2 or 3 years and work 23-hour days with the expectation that, well, they're going to leave and there are going to be 100 more who want every job. So there's a reluctance to change and an aversion to risk. What I urge you going forward is that you turn each of these around, each of these particular bullet points, and take the opposite, and that's how you're going to need to think as an entrepreneur and how you're going to need to think if you're going to pursue a career as a solo attorney. And we live in a time it's both very scary and very exciting at the same time because things are changing every day. And what I think we'd like to do together today is try to figure out how do we as attorneys and as solo practitioners respond to that change. Lawyers have F8 syndrome, and this is a story I heard an attorney from Southern California tell. He was a graduate of Bolt, of Berkeley, worked on the law review, very distinguished law school graduate, and he went down and he worked for a major defense firm in Los Angeles. And his first day of work, the senior partner put a complaint on his desk and said, come up with some affirmative defenses and have it to me by tomorrow morning. So he said, so he launched himself into the library and he labored and he worked and he researched all the various affirmative defenses and he eliminated the ones that weren't relevant. And he finally came up with 12 affirmative defenses and had a brilliant analysis of each one. And he presented it to his senior partner the next morning. The senior partner glanced at it and said, all right, good, come up with 20 more, and flipped it back to this young attorney who's now horrified. 20 more. I had to torment myself just to come up with 12. So at lunch, he's commiserating with another young attorney that he has to now come up with 20 more affirmative defenses. And the other young attorney just starts laughing uproariously. And the first guy says, "What are you laughing about?" And his friend says, "You don't know about F8, do you?" And he says, "What's F8?" He says, "Well, it's a key on your computer keyboard, but it also brings up a template where we have canned affirmative defenses. We have like 56 of them. And if you just hit F8, you'll get every affirmative defense you could ever want, print it out and hand it into the senior partner." So it was all canned. I mean, it's all a template. It all pre-exists. And yeah, most of those like latches. I mean, most of those affirmative defenses don't apply to the case, but use it anyway. And then bill your client for all the time that you were supposedly spending laboriously putting together a response to the complaint. Now, I understand that there are times that a form or a template is perfectly sensible. If you're doing a waiver, you're doing a transaction, if it's a leasing contract for an apartment building, sure. I mean, you go into Westlaw or Lexis and pull up a template. But too often, we just respond as this, the F8 syndrome, which is, well, we're going to do this the way we've already done this. We're going to reproduce the document we already used. Never mind that a huge amount of it is irrelevant to the circumstance of this case. I'm going to hit the F8 button. And what I'm asking you today is think before you hit the F8 button. And maybe you can apply, maybe you can solve things in a different, more creative way than simply reproducing what our profession has been doing now for decades. Today's themes, starting with this principle of thinking like a lawyer, let's break out the various components of our business system. Your service. What's the core value, the core service that you're going to be delivering to your clients? Now, a subgroup of this is going to be what's your specialty, what kind of law you're going to practice, but it doesn't end there. It really goes into your service. We are a service profession. At the end of the day, you're being paid to successfully deliver and execute a service to your clients. Now, your playing field is your specialty, whether it's family law or wills and trust or personal injury, but it's a question of what is that service that you're delivering, that total service that you're delivering to the person who's paying you. We're going to talk about the clients, which is you have to be targeted. We're one person in a solo practice. You can't serve the universe. You can't serve the world. You can't even serve all of Sacramento. You can serve a very distinct and a very focused subgroup of the potential clientele with your service. We're going to think about your operations, which is everything from the client going back into how you organize your day, the technology you use, physically where you work, and everything else about the system that enables you to provide your service to your clients. We're going to think about your profession. Law is a profession. We don't always act in professional ways, but we are nonetheless a profession. And as a solo practitioner, you're going to have to allocate time for your growth as a professional. I want to talk about finances and your financial health, both within the practice and more broadly your household and managing to keep up with your bills and stay financially healthy. And then finally, I'd like to talk about just thinking about your life. Being an entrepreneur, there's a price to be paid in terms of your day-to-day happiness, your family, the people closest to you, and you have to think about that in addition to all the pragmatics of your solo practice. So let's get back now to this notion of why you should not think like a lawyer. Can anyone tell me what movie this is a scene from? Sorry? Princess Bride, that's right. Andre the Giant was the actor on the right, and he's one of my heroes on my Facebook page. When instead of putting my photo there, I have a photo of Andre the Giant. And the reason I'm referring to, have anyone seen this movie? It's really a wonderful movie. It's really a wonderful movie. And Billy Crystal plays the wizard. And the good guys in the movie bring their hero, who they think has been killed and died, and he's stiff, and they bring him to the wizard, hoping that the wizard will be able to resuscitate the hero, bring him back to life. And the wizards, they say, well, he's dead. And the wizard said, no, he's not dead. He's mostly dead. And there's a difference, because if he's mostly dead, that means he's a little bit alive. And the wizard is able to resuscitate the hero. Now, the reason I'm telling you about Billy Crystal as the wizard is I think this applies to the traditional practice of law. It is mostly dead. It's a little bit alive, and there will continue to be law firms. There will continue to be traditional practices of law, particularly in urban centers like Sacramento. But the practice of law as we know it is mostly dead. Lawyers used to be able to command private access to all this information, cases, Supreme Court briefs, accessing the law itself used to be very difficult for the average person. You had to go to a library and go through all these stacks of books. Well, now on your cell phone, you can command access to all kinds of information right here. There's more on here than there is in the Harvard Law Library. Access to information has changed. Clients have become a lot smarter about paying, and they are more demanding in terms of getting value for the money that they're paying. So those of us who just used to come through law school and thought, well, we'll get a job as an associate at a big law firm and move up, or a medium-sized law firm, those jobs have gone away. And most of them are not coming back. So thinking about how to be a solo practitioner is actually, it's very smart, because you're recognizing the reality of the practice of law. And to only think in terms of being an employee at a law firm is no longer recognizing the true landscape of the legal profession. Now, before continuing, let me just take a break. Does anybody want to make a remark at this point, or have I triggered anyone thinking it at this point? Because I do want this to be interactive. So let me just take a moment, and would anyone like to make a comment? If not, let's go on. Now, continuing this analogy, the screenwriter for The Princess Bride was William Goldman, who has some wonderful credits. He did Butch Cassidy and the Sundance Kid. He did The Sting, Princess Bride, The Longest Day. And in his memoirs, nobody knows anything. Not one person in the entire motion picture field knows for certainty what's going to work. Every time out, it's a guess, and if you're lucky, an educated one. Now, I'm applying this to what we're trying to do here, which is reinvent ourselves as solo practitioners. The legal profession has changed. Clients have changed. A lot of the old truths now don't apply anymore. So we're figuring this out. We don't know what's going to work. The best you can do is try a sensible experiment, try to hedge your bets, and see what's going to work. I have a practice when I talk to other attorneys, when I heard words like never, always, any kind of absolute, I tend to believe, number one, that it's probably not true, or if it is true, it can be changed on the margins. Never go to a client's house. Always do this. Never say a potential number in the client. I mean, all these absolutes, like the 10 Commandments. Well, maybe they were true 30 years ago. Even that's questionable. But they're certainly not true now. So especially, and you'll sometimes brainstorm with friends and people you went to law school with. I'm thinking of doing this. I want to do this. And believe me, it's going to evoke some declarations from these other people. That's a terrible idea. You never do that. You never do that. You never let the clients, you never say, I don't know, to a client. You never this, you never that. But when you start hearing those trigger words, you've probably hit a nerve. And it's probably all the more reason to think, this is interesting. Let me pursue this. Let me try to change the dynamics here. But to quote William Goldman, nobody knows anything. and when you start hearing these absolutes, resist them. So I want to give some examples of how other people out there are changing the game. And now, not all of these ideas are going to work. Not all these ideas are going to have a business rationale. But I want to show you some of them because I think it's very stimulating to see what some other sharp minds are doing. Has anyone here heard of or dealt with this company called Fixed.com? Okay. Their niche is people who get parking tickets. They're in San Francisco, and you download an app on your cell phone. Now, as all of you know, when you visit San Francisco, parking is very difficult. So you park someplace, and you come back, and you got the parking ticket. And you're looking around saying, well, that's, today's Saturday, and it only says this applies on Tuesday, whatever. I'm more feet away from that driveway than I should be. So you snap a picture of your situation, and you email it into Fix.com, and you say, hey, this is what happened. And they're citing regulation 1.732. Now, the people at Fix.com have lawyers who are very well versed with San Francisco parking laws. So they'll email you back and say, yeah, we think this is challengeable. We think that it's a mistake, or we think you're in the right and whoever gave the ticket's in the wrong. And then you pay a fee, and they will help you fight the parking ticket. And the fee is much smaller than you would have to pay to get your parking penalty. So it's the technology of the cell phone, and then it's using free contributing lawyers who become very well versed. And if you've ever looked at San Francisco's code of parking laws, I mean, it's very complicated. It's very difficult. So in law school, when we think of the role, when we think like a lawyer, we don't talk about helping people fight parking tickets. I mean, we talk, you're going to argue in the Supreme Court, you're going to be at an international tribunal for war crimes. You're going to be doing all this great stuff. But how do most people in Sacramento and in California interact with the legal system? Well, it's much more likely to be a parking ticket or a property line dispute with a neighbor or a controversy because they're building a new patio and they're arguing with the building code, or they had their dog off leash and they got a citation. Just the everyday interactions that people have with the law. And the people at Fix.com figured out a way that they can make money off this interaction that people have. Closer to home, this is a company, and their headquarters is actually just over on J Street. They're like J in the teens. Has anyone dealt with Quick Legal? Okay, they're a middleman, and if someone, a member of the public, has a need for a lawyer, you download their app, and then they have lawyers in their collection, so you communicate with the client either by voice over the cell phone, or you can actually see them. It's a variation like on Skype. You're talking to them. So very easily, very inexpensively, a client with a problem and a lawyer who wants to help deal with that problem get connected. So you don't have secretaries, you don't have appointments, you have this, you have a quick connection. And if the lawyer can provide a service to this person, then the two of them figure it out. So very, very interesting concept. And I think we just start thinking about texting and cell phones and the iPhone, just all the revolutionary potential in this little piece of equipment here. It's going to have an impact on what we do as lawyers. Quick Legal. Now, a little different approach. This is counsel in the cloud. So this would be if you want to serve businesses. And there are companies that either have an in-house counsel or they have outside counsel that's virtually their full-time counselor and representative. So this is a service where, again, they'll get freelancers or temporary attorneys working on a freelance basis. They'll have a business client, some of which are significant large businesses, and they provide in-house counsel support, but on a distributed basis. And the lawyers can be anywhere. They can, they can be on vacation in Cabo San Lucas sitting on the beach with their laptop. They can be drafting documents. They can be providing the service. It ends up being quality work delivered at a very affordable price to the client. Inkcloud counsel makes money as the middleman, and the attorney makes money. So this is a way you can even deliver a service to a $30 million company as counsel. They figured this out, and you can see how deep a discount they can offer. These companies have raised significant amounts of venture capital. They're competing with LegalZoom. Has anyone here heard of or dealt with LegalZoom? Can anyone tell me and what is LegalZoom? Ma'am, can you tell me what LegalZoom is?
It's one of the Simpson attorneys' businesses, right? I can't believe I can't remember his name.
It wasn't Kardashian.
No, definitely not. But it's similar, where you go in and you can access documents and basically do your own legal work.
Right. So if I
or a non-lawyer can do
right,
it.
right.
Or lawyer, but a non-lawyer.
And it's document driven, right? I mean, if I need a document, I need a lease, I need something like that, I go on. Yeah, they spent a lot of money in advertising. These are that model. They each have some spin on it, or they have more interaction with an attorney, or they have a different portfolio of documents. But it's basically, you're going to a website to get your legal service, as opposed to calling up and trying to get an appointment with a lawyer. And particularly the younger generation of people are just more and more intuitively turning to apps and the internet and digital solutions for things that they need. Now, and let me mention here, as we're trying to think in an innovative way, we can talk all we want about technology, but let's also remember that there's a segment of our population that is not savvy technologically. They either choose not to be involved or they're not. The penetration of cell phones among adults is about 90%, which is amazingly high, but of course that means that about 10% of adults don't use cell phones. Or if they have a cell phone, they're going to use it in a very limited way, maybe just for voice. They're not going to send emails. Increasingly, I'm encountering people who don't have computers or they don't have laptops, and they depend on the cell phone. But I don't communicate with clients by email. Because they don't have email, they don't open up email. Something like 14% of American households do not have bank accounts. They do not have bank accounts. Having a bank account is pretty expensive. I mean, you have to keep a certain minimum amount in there. And there are other barriers that if you're living paycheck to paycheck, you don't keep a bank account. I mean, that's why you see people paying their PG&E bill at service centers. Now, as a profession, these people, we have to figure out how are we going to serve people who maybe don't get email and maybe don't have bank accounts and maybe are just not in what we think of as the mainstream of working society. And these are people who also have legal problems and have a right to counsel. And someone among us is going to figure out how do we deliver services to these people in economical and efficient ways. That's a good way now to talk about, let's talk about thinking about your service. And I say thinking about service because obviously you start with what kind of law you're going to practice. But that is, again, just the start. So just out of interest of the people attending here, let me call out a few fields of law and by show of hands if it's an area that you've practiced in or that you want to practice in. Now I'll start my own area of law. I'm an employment lawyer and I represent plaintiffs in private sector employment law cases. Are any of you here in the practice employment law? Okay, very good. Are any of you here in personal injury, either on plaintiffs or defense side? Okay. Family law. Okay. Wills and trusts. Okay. Intellectual property. So each of these names represent enormous segments of practice. If I talked about tort law, that could be automobile accidents, and it could be slander and libel and defamation cases. So when we talk about your service, I want to go beyond that initial thought of this is the kind of law that I practice. And I'd really like to encourage you to think about a niche and be a niche competitor. And my own saga was I did contract work after law school for any number of lawyers doing different things. I just wanted to get the experience of being a lawyer. And I did family law, and I did tort law, and I did other things. And I worked for someone who did employment law, and I really enjoyed it. And I enjoyed the stories, and I enjoyed that it was the issues that people have in the workplace. So I decided to do employment law. Then I decided I was only going to do private sector because public sector government employment was a much different animal. And I had worked in the private sector, so I felt I could understand it better. And I felt I was only going to deal with sizable large companies like Fortune 500 companies and not get involved with, say, mom and pop shops or small family businesses where there was a whole different dynamic. I was going to try to deal with companies that were at least large enough to have a human resources department and lawyers because they had the means to be held to a higher standard of the way they treat people, and they should be held to a higher standard of the way they treat people. And then I decided to only do plaintiffs' work because, number one, it was underpopulated. There was a lot of people, talented lawyers in town, doing defense work. There were fewer who were only doing plaintiffs' work. And also just my values and my personality and the kind of things I enjoyed was more consistent with the plaintiff side in the workplace issues. So you can see I kind of went through a progression here of starting with a wide focus and then getting narrower and narrower and narrower. And I think that's a key to survival as a solo practitioner, a clearly defined niche. And then once you have that niche, try to drill down a little deeper. And can you sub-segment that niche? We can't provide or sell our services to everybody. In fact, we're pretty limited in terms of the universe that we can sell. Now, to help you think about identifying that niche, let me suggest that you think of a triangle. And you want your solution space, you want your solution space to be in here. So you want to be somewhere within that triangle. Now you want a market that's underserved, okay? If there are hundreds and thousands of other lawyers doing what you're doing, it's going to be very difficult to differentiate yourself. Like I found in employment law, there was a small community of people in Sacramento who only represent plaintiffs, and they were very good, but it wasn't numerically that large. And there are a lot more clients who need services than there are people providing it in Sacramento. So I felt it was an underserved market. Then another leg of the triangle, let's talk about logistics. Is it a kind of practice that you can realistically say as one person, as a solo practitioner, you can get it done? So to give a counterexample, let's say I only wanted to do class action suits where I was going to have hundreds and hundreds of plaintiffs, okay? Now, you have to be running databases. You need to be doing enormous amount of logistical support. That is not something that's going to be rational for a solo practitioner, okay? That's an extreme example. But in thinking about your niche, think, is this something that I can handle in terms of the demands it places on me as an individual? And for me, employment law for plaintiffs, the answer is, well, yes. I mean, if I have a caseload of 6 or 7 or 8 plaintiffs, the complexity of the cases is manageable. Yeah, I can handle it. I can handle it as a solo. And then thirdly, is it a type of law that you can learn and enjoy? And you want some of it to come from inside. You want some of it to come from your heart. As a contract attorney, I was able to see there are certain types of law that I just didn't like or it just didn't feel right to me. I really, really had to force myself to read the educational literature. And some things just work for a person and some things don't. And if it comes from the heart, if it comes from the passion, so much the better. Now, applications are down at law schools, and we hear a lot of chatter out there about how hard it is for lawyers to get a job. But when you think about your niche, let's be realistic here. In a complex society, people need lawyers to navigate through the complexities of life. And our society is getting more complex. I mean, it's not getting less complex, it's getting more complex. Getting health care now is an example. Buying a house gets more and more complex. So there are people out there who need you, who need your service in some component, in some niche of their life or their business or their family. And now they may not know that they need you because that it hasn't happened yet or they haven't thought about it yet. But they do need you. And it's up to you to figure out how you can define that service, how you can deliver it, and how you can make it work. Now, this is a place to keep an open mind. What kind of law are you going to practice? Now, I know in law school, we all had experience. I hate contract law. Oh my God, property law. I had to take NOTOs every day just to stay awake. We all have our sort of internal actions and reactions. I think first year we all dreamed about being prosecutors, and we all thought being a DA, criminal law, was glamorous. I mean, a lot of fields of law can actually be pretty interesting once you get into it and once you start making money at it. I mean, there's nothing like actually doing a transaction and getting paid for something. And then next thing you know, you're listening to CLEs and you're reading everything you can about it. So keep an open mind. There are a lot of really tiny and arcane niches out there. But again, you're one person. You don't have to have 2,000 clients. You have to have a small, sufficient number of clients. So keep an open mind. Make yourself different. Differentiate yourself. A commodity in economics, if you remember from Economics 101, it's interchangeable. It's corn, it's soybeans, it's pork bellies. One is pretty much the same as the other. You don't want to be a commodity, and you don't have to be as a commodity. You can find some way to differentiate yourself, your service, the way you charge for your service, the way you interact with your clients, the way you deliver your advice. Don't be a commodity. Now, are any of you who are football fans can identify the gentleman there holding the pointer? You're probably over the age of 30. Yes?
Vince Lombardi,
Okay. Who was Vince Lombardi?
coach for Green Bay.
Green Bay, right. And why? Actually, the Super Bowl trophy is called the Vince Lombardi Trophy. He's very revered. Why is Vince Lombardi remembered with such reverence?
Win record.
Okay, he won. He won a lot of games. But what was identified with him in terms of his personality and his theory of the game? It was basics, right? It was basic football. And the Green Bay Packers used to what was called run a sweep, which is he's illustrating here, which they'd get in front of the guy with the ball and they'd block everybody out, and the guy with the ball would run and get 5 or 6 yards. My point here is, again, in thinking about your niche and thinking about what you're going to practice, there's a natural resistance because people will say, well, David, if I only do private sector employment law, aren't I shutting myself out to all these other cases? Or, if I only do personal injuries relating to bicycles or elevators in public buildings, I mean, what if somebody else wants something else? I mean, aren't I like turning away business? And the answer is no, because people have problems. People don't think in terms of lawyer categories. They think in terms of, you're a lawyer, you solved this problem for me, and now I want you to help me with something else. And you can start with a narrow focus, but if you have the opportunity to do something else, do it. I mean, why not? If somebody knows you and then they say, can you help me do revise my trust? If you feel that you can competently educate yourself to do it, do it. Or help somebody with a dog bite case or whatever it is. You're not excluding the potential for growth by choosing a niche and marketing a niche. You can start narrow, but then sweep wide. people have legal problems, and if they know you and trust you, they want you to be their lawyer. And if you can't personally deal with their problem, now you can start making referrals to other people, and then they'll counter-refer to you. So I challenge you in your thinking, start narrow and sweep wide. Now at this point, I have more. I'm going to suggest we take our break now. Let's take about 10 minutes to just about a little before the hour, and take a break, and then I'll be here if any of you would like to talk to me personally. So let's take our break. All right, welcome back. We're into the second portion of our session today. And during the break, a gentleman asked me a question. We went back to this idea of templates and the F8 syndrome. And might I ask you, sir, just to sort of paraphrase or recapture the point that you were curious about?
Yeah, I was curious on the issue of the templates, and that is the use of perhaps non-relevant writings, if you will. And the question I had for you, isn't this also a function of the judiciary itself? The judges expect certain things,
Yeah.
and it makes them, puts them in their comfort zone.
Right.
And so the question is, well, not only is there an education or re-education of the lawyer to perhaps you say different approach, but it has to be and also similar realization or a similar indoctrination on the judiciary, because they're the ones that are calling the shots. They're
Right,
the ones that
right.
are making the decisions.
Right. So I guess to paraphrase the question, since our ultimate audience is the judiciary, aren't we sort of limited to do what the judges expect from us, so that we before we take liberties, shouldn't we be giving them what they want? And I can't speak for judges. I do know that when I talk socially with them, they'll say, you know, I so appreciate a well-written brief, or I so enjoy when I have something that is literate and I can read it and it engages me and that makes its argument. And I really can't believe that, I mean, I think we lawyers blame a lot of what we do on judges and say, you know, this is what judges expect and this is what judges want. Well, that doesn't excuse lawyers doing things that for us are lazy and non-productive, like just taking a template. So I'm inclined to take risks, and I'm inclined to take chances. And if I worked at a big law firm, I'd have to hit F8 and project the template. I'm willing as a solo practitioner to do things where I don't know if the judge is necessarily going to be compatible with it. But I think if it helps me make my argument and it expresses and it's engaging, I'm going to go for it. And when you say the judiciary, it might work for one judge and not for another. Maybe the best answer I could give you is know your judge. And if you're dealing with someone that you understand really is a stickler for traditional ways, well, yeah, I mean, then give him or her something that is definitely, you know, specific. You know, in the Sacramento County Magazine, some of the people and the judges in Law in Motion do write articles about what they expect in pretrial motions, and you can read that and present that. But I think, you know, if I have a chance to be an advocate for my client, no matter how dull as dishwater the document is, personally, I'm going to take that chance to be an advocate. And I'm going to take that chance to make something jump off the page and influence the judge. Any comments on that? Any follow-ups on that? Yes.
I just think that your point about the writing is very important, because when you're stepping out of the box, it has to be well written. And if you step out of the box and it's not written well, then the judge is really going to be adverse to it, versus a refreshing approach that is also well written is going to catch their attention and possibly, you know, turn their opinion towards your client.
Yeah. I think to paraphrase, you can be in compliance with the basic. I mean, don't use an eccentric font, okay? I mean, use Times New Roman 12 point, and use 28 lines on your page. I mean, the the basic parameters, don't look for trouble. But don't include 3 pages of template and boilerplate because that's the way your law firm used to do it. Never mind that it really doesn't relate to the point you're making. I mean, lawyers think if a little bit is good, more is better. So if I can put in 5 points, then I'll unload another 8 points of argument and stick it in there because, well, why not? But I appreciate your point. All right, let's resume now, and we're thinking about these different aspects of what you do. And let's go on now to thinking about your clients. Because ultimately, it's who are you going to serve and how are you going to serve them. And occasionally I hear lawyers say things like, I really enjoy the practice of law, I just wish I didn't have to do it with clients. And clients are kind of thought of as this sort of unfortunate, regrettable element that it would be nice to escape if you could, but you still have to deal with it. And when I say clients here, I'm really thinking about the public. Let me take a little tangent in that a very valuable form of being a solo practitioner is to be a contract attorney to other lawyers and other law firms. Has anyone taken this approach where you are a contractor to law firms? And this would be the equivalent of being in a wholesale business where you're working within the industry as opposed to retail to the public. And there are people who will only write appeals for law firms. There are people who will be a law and motion specialist to law firms. There are people who will write demand letters for law firms. So you are selling your services not to the person on the street, but to law firms that you can sell your services to. Now this is a very viable model, and it's something that's worth thinking about. It might help you in terms of malpractice because in some cases your client, the law firm, might extend its malpractice protection to you. And you can bill by the hour and you can get projects from law firms. And sometimes they'll encourage you to work on site. So this is a viable model. I think just the caution is you ultimately don't learn and develop yourself to go out to the public and sell yourself to the average person. You're dealing with other lawyers. And I think it's just invaluable to test yourself and push yourself to know what it's like to sit down at a table with someone who has a problem and be able to diagnose it and basically control the client, because as a contractor to law firms, you don't have contact with the ultimate client. You're dealing with the law firm. But it's a way of thinking that if you say you really enjoy law in motion, or you really enjoy doing appellate briefs and oppositions, your clients could be other law firms. It might be the law firm that you're working for currently now full-time, and you're going to become an independent contractor, and your first client will be your own former law firm. But when I think about how most members of our profession position themselves vis-a-vis their clients, I think of a castle with a moat and protection, and the lawyers are inside the castle, and those grazing animals there in the grass, well, those are the clients. And the concept I'm trying to project here is that you put as much distance between yourself and the client as you can. This is the traditional way that I think our profession thinks about clients. We're not a client-friendly profession. I worked for somebody, I worked for a senior attorney, and he said, don't call the clients on the phone. It annoys them, it bothers them. If you have questions, wait till you have 5 or 6 questions and then just make one phone call. And I was thinking, well, how often do you hear clients complain, my lawyer called me too much, and my lawyer was too concerned to know what I was thinking. What this lawyer was really telling me is he didn't want to be bothered with clients, and it was unpleasant to him to have to interact with them. If you talk to people who have lawyers, the number one complaint, and the number one complaint to the bar, is that my lawyer didn't return my phone calls. And in any other profession, if you're getting a mortgage from a mortgage broker, or you're having an architect design your house, you routinely expect to be in steady communication with that person. And you wouldn't tolerate, say, the architect of your house going 4 or 5 days without returning your call. You're building my house. I'm paying you. I want to know what's happening with the third bathroom. Call me back. Our profession doesn't do that. We're busy in our castle. And sometimes you can't even talk to a lawyer. You're lucky if you get an assistant or a paralegal. Sir, yeah.
Well, David, I was going to mention that the biggest problem I've had in a sole practitionership is that I went 8 years without one phone call from the internet. And literally it took me that long to figure out how to get search engine optimization to work, because I was competing now against the big boys as a sole practitioner, people that I'd left, and finding me was that difficult. And my lesson in life is that, by God, you've got to get someone that can make your website the best. And
Okay.
you pay them by the month, and it's $350 to $800 a month. By God, that's the only way your phone's going to ring. Then they're going to find you.
So you're thinking about the marketing challenge as a solo practitioner.
The biggest problem for a sole practitioner.
Right, right. That's true. And most of us are under-marketed. I'll be talking about marketing a little later, but I think your original point was your problem was not that you had to return phone calls. Your problem was that you didn't have any phone calls to return.
Yeah, correct.
Okay.
So I had to work, you do all the other marketing, going to whatever bar association meetings, every cocktail hour, et cetera. That all works fine, but
Right.
you need those cold calls coming from people that say, I need your help. And to find you is difficult.
You've been in solo practice for about 8 years? Okay. Is the dynamic changing now than when we reflect on the early years in terms of?
I think it is. But still, the big boys, the Morrison and Forresters of the world can afford $1 million a month
Right.
in marketing. And so they'll get 90% of phone calls.
Right.
And you're spending $800 a month, and you'll get 1 or 2.
Yeah.
And 1 or 2, you're only going to nail 1 client out of 4.
Right.
You're lucky. So it really.
Now, some of that I'd relate back to how you think about your niche, because the big boys are wall-to-wall competitors, and they're going to have vulnerable points within that, and you might be able to outmarket them within the niche. But if you're going head-to-head with them wall-to-wall, sure, they're going to roll over you. Sir, did you have something?
No, I was just going to comment on him. Maybe the practice that he does is very esoteric and not one that you would call a lawyer for, except maybe another firm that might need that specific work he does.
Yeah. Well, just to clarify, just when I'm talking about phone calls, my context actually was once you've engaged with the client and you're working with him and her. I think we can talk later about that initial contact, whether it be a phone call or an email. But my analogy of the moat and the castle, I'm thinking about once the person has signed on with you and you're working with them and trying to move towards a conclusion. And I think lawyers have a lot to be desired in terms of their day-to-day communications with clients. I try to respond to every time a client reaches out to me within the same business day, or within 24 hours. And certainly with text, with email, and with phone messages, and I mean, there's just a lot of ways, even to tell somebody, I know you're trying to reach me, I'm sorry I can't talk right now, I just wanted to let you know, I got your message, maybe Monday afternoon, if you're around, we can talk then. And I urge you to clientize your practice. I mean, every client is not only that particular case, but every client is somebody out there walking around who's thinking about you and talking about you. And if you can build a critical mass of clients you've already served, you have a sales force. And the sales force, you don't have to pay them commission, you don't have to pay them salary, you don't have to pay their health benefits. They're your sales force because they're satisfied clients. And we can't guarantee success. I mean, if I'm a litigator, I can't guarantee that we're going to win, the judge is going to side with us, and that you're going to make money. But all I can guarantee is I'm going to work very hard on your behalf, and I'm going to work with you, and I'm going to communicate with you. You know, if I have a case now against a Fortune 500 company, they have 6, 7, 8 lawyers that can work against me. what I can offer is good teamwork and communication with my client. Maybe we can be a better team than those 6 or 7 people are on the other side. I mean, small focused teams can defeat large bureaucratic organizations. So work with your client, and sometimes it's an inconvenience, and occasionally clients will abuse the privilege, and they'll call you at home on Sunday night, or they'll annoy you, or they'll take more hand-holding. That comes with the territory. I find the majority of them are delighted that you're so accessible. They're respectful, and they don't abuse the access. And they're really just delighted that it's a lawyer who has good communication skills and wants to stay in touch with them. Courtesy is a very strong differentiator. Be courteous and be a good communicator. Let's talk now about how you're running your practice day to day. And now those of you who have come up through medium and large size law firms, a lot of the day-to-day practice you don't do. I asked somebody the other day if he knew how to serve a process in a federal complaint. And he said, I don't know, my paralegal does that. And you hear lawyers say that all the time. Well, my secretary handles that. Gee, I don't know what the deadlines are. I mean, I don't know which form to use. I don't know this or that. I mean, my secretary does all that. Now, that's wonderful if you're in a big law firm, because you can sit in your office and think great thoughts and be a strategist. But once you're a solo practitioner, you got to do all this stuff. You know, you got to figure out how to, over here at Sacramento Courthouse, you know, how do I file a case? The clerks no longer take the case and stamp it at the window. So you've got to figure out, how do you put a rubber band around your documents and slide it into the box? You've got to figure out your deadlines. Major cause of malpractice is blowing deadlines. So let's talk about operations, and those of you who are already in solo practice might have some observations. Calendaring, actually for malpractice insurance, you have to have not only a physical calendar, but they want you to have some kind of electronic backup. And I've been very happy with, it's called deadlines.com, and you can run your calendar, and what's interesting here is they have lawyers working for them. So if you give them a jurisdiction and the type of case you filed, they actually give you what the major cutoffs are. So you can get reminders saying, hey, July 1st, last day to file an opposition, last day for this or that. So they actually have content that comes up, and it's affordable. It's $20 per case. For me, it's pretty easy to use. Now, there are other services that are similar. You can shop around and try it. But I'm not the kind of person who has the discipline every day to get out my calendar and write everything down and count back 30 days and do all that. And plus, sometimes when I count back 30 days, I miscount and I'm on the wrong day. Do it online and let these people create the calendars and create that. I'm terrible at things like filing and putting things away and getting documents. I mean, a lot of them disappear in my briefcase and I don't see them again for 5 years. Also, hard drives crash. I suggest you find some form, what's called cloud-based storage. That's a technical term. Can anyone tell me what that means when I say cloud-based storage? Sir?
Means I can get it anywhere I'm at, as long as I have an internet connection.
Right.
Because it sits up in the cloud.
Is the file actually on your laptop or on your device?
No,
Where is it?
it's in the cloud on a server somewhere remote in Utah.
Right. It's somewhere out there. But what's the advantage of that?
The access and the backup.
Right.
I don't have to worry about my computer crashing.
So if somebody steals your laptop, do you lose the file?
I don't lose the file. I don't have any confidentiality issues.
Right. And you can be at any device anywhere, and you can access that file, which is sitting at a server in Saskatchewan or Lower Slobovia, and it's there, and they have better firewall protection than you can ever have on your own device. Dropbox offers a pretty good amount, and it's free. The service is free, and what they're hoping is you'll ultimately put so much in there, you'll have to move up to the next level of capacity, and you'll buy storage space. And if you have the file on your screen, you take it and you drag it over and you just drop it in the Dropbox icon, and then poof, it magically goes off into your Dropbox locker off in the cloud. So recommend, I mean, you might now be saving to a flash drive or something like that, which is good. I mean, you have a backup or a backup disk, but this is even better than that because it's no longer a physical entity that can get damaged or lost or stolen. So I also, my website is with GoDaddy, and as having the website there, they also offer some cloud-based storage. So there are various vendors and various ways you can do it, but I think just figure out some way to back up what you do in the cloud. Scanning and filing, if you don't have a scanner, I think you should get one. You can reduce the amount of paper. You can sign documents or coming in. So a scanner now is, I think, almost irreplaceable.
One right here. There's an app that's a scanner that scans it straight to PDF.
Can you scan off your cell phone? Okay. And it reduces, I mean, paper is not a good thing. Paper gets destroyed, paper gets moldy, paper has to be filed. So the more you can reduce the amount of paper, the better off you are. Once you get going, you might need support staff. There are people, very good people. I work with a person who runs my website. We mentioned websites before. I've had some research needs. There are a lot of attorneys in town, recent graduates, who are happy to work by the hour. And you've got to be judicious, but there'll be certain times you say, I could do this myself, but is this the best use of my time? Is this the most value-added use of my time? And is it better off contracting this out to somebody for 4 or 5 hours to do this for me? And then simplify your operations. I mean, if I have to think about anything too much, it means I don't want to do it that way. And if it's almost reactive and intuitive, I can just do it naturally, then that's great. Anybody recognize, this is from a movie. Can anyone tell me what movie this is?
Lincoln Lawyer.
Okay, yes. And what's the name of the actor is?
Matthew McConaughey.
Right. Now, what's the premise of the Lincoln Lawyer? Has an office in his car, right? He drives around Los Angeles. He's either at the courthouse or he's at the client or he's at in the judge's chambers. Why do I need an office? As you start in solo practice, this is a decision you're going to make. It's very personal. Speaking for myself, I'm not an office person. I don't like offices. I don't like the feel of them. I don't like being up on the 36th floor of a building. It's just not something I'm happy with. I work out of my home. I meet clients in public places. I rent, there are by the hour office rentals. I work at a place called Regis. This Sacramento Public Law Library has wonderful conference rooms right around the corner here, very affordable price, right across the street from the court. I mean, it's hard to do much better than this building right here. By the way, you also are a staircase away from Westlaw and practice guides and reference librarians who are available to talk to you. I mean, you can use the law library here as your virtual office, as your hub. Now, some of you may have young children at home, you may have other situations, but again, we're a very traditional office, and people think, well, I need a waiting room, and I need a lounge, I need a conference room, and I need all these trappings, all these things. Well, that's 20th century thinking, or 19th century thinking. And do you really want to start out on January 1st of a given year, you're $75,000 in the hole because you have rent and insurance and equipment and parking and all these other infrastructure expenses so that you have an office. So if you're just about to step in and start a solo practice, I would challenge you to think, can I be virtual? I mean, if I have a cell phone and on a keyboard and my brain, why can't I be a lawyer anywhere? Incidentally, if you can see the license plate there, it says NT guilty, not guilty. Can anyone tell me what is a flaw with that license plate?
Too many letters.
Too many letters.
Too many letters. It has 8 letters, and you can only have 7. My license plate says wronged, because wronged at work. In the novel that this is based on, the license plate actually says, I walk 'em. He's a defense attorney. I walk 'em. All right, the next category is think about your profession and your professional development. This is an interior shot of the U.S. Supreme Court in Washington, D.C. And as a solo professional, you start to think about developing yourself as an attorney. Think about other areas of law. Think about ways you can do pro bono service. Think about just how you can be a valuable member of your community. And it all comes back. I mean, if you want to get, first you have to give. But it's all part of building yourself as a practitioner and as a member of our practice. The county bar or the state bar, nonprofit boards are very eager to have lawyers on them. And you'll be welcome. And you're meeting your fellow directors, often they're very prominent people in the community. And you're learning about making the decisions as a board member. You're learning about corporate governance. You can do it, if say you have a passion, you love gardening, or you love museums, or you love equestrian competition, serve on the board of a group that does something that you love. It's an activity you'd like to be involved in anyway. And I started when I got out of law school, and I didn't have a job, so I started working on boards, and people would turn to me and say, Dave, can we do that? Or Dave, are we in compliance with the law if we do that? And I realized, hey, they're asking me because I'm a lawyer. And I'd say, well, I'll look into that and I'll report back to you. And I developed my skills as a counselor. And it was really pretty exciting because I said, hey, I'm a real lawyer now. Let's talk about your financial health. What movie is this? Can anyone tell me?
Goldfinger.
Called James Bond, Goldfinger. This was the Sean Connery, the original James Bond, and in my opinion, the best of all the James Bond. So let's think about your finances, because if you don't handle your finances correctly, you're going to be in a situation very similar to Mr. Bond in this picture. Like any small business, it takes a long time to go cash flow positive. I think a good rule of thumb is 2 years. You should have the financial resources to go 2 years making either very little money or almost no money. Your experience might be better. You might come to positive cash flow sooner than that. Would you agree with that, 2 years?
You know, I didn't have that problem, but all the interns that work for me, they're taking 2 or 3 to even get going. It's terrible today for a young kid. But no, I'm 62, so I didn't have that problem.
Okay. But I mean, if you're opening a restaurant, I think it would be very similar. If you were opening any kind of business, try to have resources and say, if I have 0 net in the next 24 months, do I have to live in my car, or can I get by? And I think it's a prudent baseline. Hopefully, your curve will be better than that, but I think you have to assume that scenario. Don't commingle your personal funds and your legal practice. Very good way to get in a very serious problem. You'll need 2 accounts. You'll need your practice account, and then you'll need a client trust account. Spend a little time and shop around for the banks here in town. They vary widely. I found one that had a lot of freebies and a lot of extra services. They also invite some of their clients to networking events. It's a small community bank here. So invest a little time, because you want your banker to be your friend. And things like when you want to refinance your house, or if you have other financial needs, they're going to like the fact that you're a business client. And so shop around for that. And then finally, thinking about your life. Sir, yeah.
Before we move on to that, I want to add one other good comment, and that is that when I got started, you're smart to sublease space if you want an office, if you need the trappings of an office. I'm one of those that has to have that. you can get space at $1 square foot, or $1.50, and then don't worry about moving around to office buildings. I've moved 5 times, but when you sign a real lease and you're actually putting your name, it's $275. I mean, it's expensive as hell. I mean, you can really beat it by subleasing, and there's a lot of space available at that.
Good. Okay. Thank you. Yeah.
Another option that goes along with that, what I do is the virtual office. On my business cards, on everything that I have a downtown address, and I pay a monthly rate of like $60. My mail goes there, they do my phone service. If I need to meet with the client and I really want it to be in an office space,
Right.
I go down there and I meet with them there.
Yeah.
So you still look like you have this big, nice, fancy office when you're sitting at home.
Yeah. You can project that, and you can decide, and you can meet where the client wants us. Some of them would rather meet at a Starbucks near their house, and some of them, if they work downtown, it's going to be more convenient to meet there. What movie is this? Anybody know? Orson Welles? Citizen Kane, based on the life of William Randolph Hearst. Being an entrepreneur is very demanding on all parts of your life, not just the business part of your life. And I think maybe the timing is not right to have your solo practice based on the other person, significant person in your life, maybe the age of your children, the other things that are going on. I know for myself the fact my wife is my invaluable partner and is my rock of stability and helps me get through the phase of starting my own practice. It would be very hard for me to imagine if I was solo, not only in my practice, but in my life, and how I'd get through this. So think about the other components of your life in terms of your home, your stability, your partner, your children, because you want to have those in good shape, because being an entrepreneur is all-consuming, it's exhausting, it's emotional, and it's going to evoke aspects of you that you didn't even know existed. I actually think it's a very exciting journey for personal development, not only as a lawyer and as a business person, but as an individual. That when you work for yourself and you really become self-dependent, and you're free of an institution, you're free of other people, you're going on your own gut, your own hunch, your own intuition, and boy, when you succeed, it's the greatest feeling in the world, because you know that it's you and it's all you. Let's talk about resources. As I said earlier, where we are today is, I think, the best conceivable resource for a solo practitioner here at the Sacramento County Public Law Library. If you made this your hub as a solo practitioner, you have Westlaw for free. You have all the best practice guides. Not only are they free, but you can check them out. So if you're working on a document and you want the pre-civil litigation practice guide, take it home and you can renew it. And you're not buying the practice guide, you're borrowing it. They have reference librarians here who can help you figure things out. We're across the street from the court. You can rent conference rooms here by the hour. If you're not a member of this law library, you really are missing a beat. Also, the County Bar Association, we have a solo and small practice group. A lot of members of the board, like me, are in solo practice. If you're not a member of the county bar, I'd seriously consider it. I mentioned Regis. There are a lot of rent-to-workspace places. You mentioned one. If you went to a local law school, use that. I work on weekends at the McGeorge Law Library. Again, there's reference librarians. There's free Westlaw. It's secure. I can walk away from my laptop and not be worried it's going to get stolen. And it's open late at night. And if you're a local alumnus, your law, I'm still paying off my student loan, so I might as well go back there and get some value out of it. And then finally, I would say, think about small business support groups, not only other lawyers, but other small business people who are in whatever field of endeavor they're in. I mean, you now have something in common with them. And think about yourself, again, not just as a lawyer, but as an entrepreneur who happens to have a law degree. So I think with that, I'm going to wrap up. I'm welcome to stay here to get some other comments. I just hope, again, I've left you with the idea that going solo is an adventure. Just don't think like a lawyer, think like an entrepreneur. Thank you all. Thank those of you at home, and goodbye.